Hi, my name is Daniel Papst. I'm Managing Director of Papst Licensing, and I have the pleasure to be on IP Fridays.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 92 of IP Fridays. Today's interview guest is Daniel Papst of Papst Licensing, and we will talk about his company, a patent enforcement company, and about patent enforcement in general, and in particular about the patent enforcement in the US and the UPC. Before we jump into the interview, I have a couple of things to tell you. It is now clear who has filed the complaint with the German Constitutional Court against the UPC, the ratification of the UPC agreement. It is the Düsseldorf attorney Ingve Stjana. He has been with a couple of larger law firms in the past, but has been a solo practitioner for a while now, and he has been known to be very critical of the UPC. The German Constitutional Court has already asked about 22 organizations to file their briefs, but now the Constitutional Court has asked 3 more organizations, and in particular the Deutsche Vereinigung für gewerblichen Rechtsschutz und Urheberrecht, GRUR, GRUR, the largest organization of IP professionals in Germany, then the European Patent Litigators Association, EPLIT, and the Association of the German Industry, Bundesverband der deutschen Industrie, BDI. It is expected that the decision of the German Constitutional Court will be delayed by this new development, and it is not currently clear when a decision can be expected. Some people think that we will see a decision in the second quarter of 2018. Then a completely different topic. Is there something like a trademark troll? Michael Gleisner has now registered over 4,400 trademarks across 38 jurisdictions around the world. These are mostly well-known trademarks that have not been registered in some jurisdictions by the original trademark holders and are now registered by Michael Gleisner in the basically white spots. An investigation by the World Trademark Review has uncovered or revealed that in the beginning of November 2017, that an additional 2,000 trademarks were discovered. So now there are a total of 4,400 trademarks in the name of Michael Gleisner, mostly well-known trademarks where the trademark owner has probably forgotten to or omitted to register these trademarks in some jurisdictions. I am myself involved in an opposition involving a Michael Gleisner trademark, so let's see how this will work out. People don't know yet what the business model of Michael Gleisner will be with all these trademarks. Lexology just reported that the Supreme Court is hearing a huge blockbuster patent case. The case is called the Oil States case. And why is this such a big deal? It is about the constitutionality of the inter partes review procedures, the IPRs. Many lawyers are uncertain how this case will be ruled, how the decision will be. However, most large patent applicants have filed amicus curiae briefs supporting the IPR system. Basically, most of them argued that they are only interested in strong patents that are enforceable. Now, let's jump into this week's interview with Daniel Papst. I'm very excited to be joined by Daniel Papst today. If you don't know who Daniel is, he is a patent attorney and managing director of Papst Licensing GmbH & Co. KG in Germany. Papst Licensing is one of the leading patent enforcement companies in Germany and maybe worldwide. And Daniel Papst is also listed as one of the key strategists in many rankings. And I'm very grateful to have you on the show today. Thank you for being on the show.
And thanks so much for having me.
So when I was young, your company was known for computer fans and cooling solutions, and now you are enforcing patents. How did that happen?
That's a quite broad question. Originally, my family started a company called Papst Motoren, my grandfather, 75 years ago. And he was also very sensitive to protecting the respective IP that was brought up by himself, but also by the engineers in the company, Papst Motoren. And so patent portfolio grew up, which ended up being around 600 patents and pending applications in the early 1990s, which is when Papst Motoren was going through financial difficulties. Our banks at the time were not sensitive to patents at all. They gave the patent portfolio a value of 0. My father saw a substantial chance to generate revenue from the patent portfolio and decided, after the company had to be sold under pressure from the banks, to buy back the patent portfolio and start monetizing the respective assets, basically by approaching former competitors in the market and acquiring products from them, trying to verify that they use respective patents, and then starting negotiations about licensing the respective portfolio to the respective companies. And since that worked fairly well, and it was also quite a bit more successful than originally anticipated, the idea grew to turn this patent monetization approach from only enforcing the former originally patent portfolio that was originally owned by the family into a service for other people. And in the beginning, other patent attorneys approached us, and they mentioned, hey, we have some clients that have patents, but they themselves do not want to monetize or enforce their patents, or they don't know how to do that. And this is how this broader approach to patent monetization and enforcement came about.
Mm-hmm. And you have grown to be one of the bigger players in the field of patent enforcement worldwide today, and you are also enforcing patents in Europe and in US and actually in many countries. And you're enforcing patents also in very lucrative fields, like in the automotive industry or smartphone industry. Who is your typical client?
That is, I think, somewhat changing. While originally we started with a focus on SMEs, so small and medium-sized companies, sometimes also single inventors, and at times startup companies that were struggling. These days, the market is much broader, and especially in the US, there are brokers that offer patents from also global players like Panasonic, Pantag, for instance, or sometimes also large companies approach us directly, like Siemens or IBM, and they have respective patents or portfolios that they ask us to take a look at in order to monetize them.
Okay, so your clients are not recruited from small companies who don't know how to enforce patents, not only, but also fairly large companies who have large portfolios and just need your expertise to enforce the patents, correct?
I think that is correct. The large companies, of course, have all the capabilities themselves. At least that's our belief. Some of them focus on some core patents that they wish to monetize themselves, and something more on the circumference, or when the portfolios grow a little bit older, then they made strategic decisions to sell those off or have someone else monetize it for them in a sense. And so I'm not sure if there's a general rule that can be applied, but it is true that also large companies that usually you would assume have the capabilities in-house, and they do have the capabilities in-house, still reach out. Sometimes they call it a lack of bandwidth because they can't deal with everything in their large portfolios.
Right. Another question. How did patent enforcement change in the last 5 years, in your opinion, and why did that change?
We believe it has changed quite a bit in the last 5 years, certainly with respect to the US. I think already about 10 years ago, Supreme Court decisions started in the US that were not helpful for patent owners, like the eBay versus Merck exchange decision that basically took away injunctive relief from a patent owner who may just seek a compensation by a licensing fee, or basically looks for damages rather than or may just want to have damages rather than an injunctive relief, and took away a very important weapon, I would say, in the or basically a core tool that a patent really is. At least in my eyes, it's a right to exclude, and that's the original idea of a patent, and that was taken away about 10 years ago. And then certainly the U.S. legislation that brought about inter partes review proceedings in the America Invents Act has had a substantial impact, because it's certainly easier today to bring a validity challenge against a U.S. patent, and I think that had a big impact. When we talk to people selling patents, they these days are much less enthusiastic because it is much harder for them to bring respective assets to the market due to the higher risk that is seen in taking a U.S. patent in for monetization, and in as such, with respect to the U.S. at least, it's a much harder field. The risks have gone up, the chances have gone down. Changes in damages law have also had an impact there in the U.S. And on the other hand, there's more activity in Europe, especially I would say in Germany, and the fact that there is a fairly efficient court system that brings you a decision, maybe not always a decision that you're looking for, but at least in a fairly timely manner. You get some guidance from the court, and with an also overseeable budget, that is certainly helpful.
Right. You just touched on IPRs in the US. That has been a big change, and some companies in the US are struggling how to deal with that new challenge. In Europe, we are quite used to that. We know oppositions, we know cancellation actions, and so on. So we are actually quite used to that. But the US, for US patent owners, it's a new thing. And some are thinking of very strange new strategies, like transferring all the patents to Native Americans in tribes in the US because they have some special rules about them. So what do you think about the IPRs, the inter partes reviews in the US?
I think in general, the idea of an independent validity challenge is not a bad idea. I don't have to tell you that in Germany, you mentioned that in Germany, you can bring a validity challenge without infringement suit being filed against you. And I think the problem with the IPR proceedings is, on the one hand, that they use a different evidence standard. It's not the clear and convincing evidence standard that you are facing in a validity challenge in district court in the US, but it's only, so to say, the preponderance of the evidence. And also it's a different claim interpretation standard, a much broader claim interpretation standard, which it seems simply unfair that there are two different standards applied, the one by the PTAB, by the Patent and Trademark Office in the US, and the other one in district court. So it seems a little unfair that the rules have changed with those significant changes in the review standards. On the other hand, the inter partes review proceeding in front of the Patent and Trademark Administrative Board, they are they seem to be a little biased towards, let's get rid of those respective patents. At least statistically, I believe over 80% of challenged claims are canceled. And if you look at the statistics in respective district court litigation, it is a substantially less amount. Of course, we have a lot of claims canceled in validity challenges also in Germany, but there seems to be less predictability, and that's what brings more risk into the equation of someone who's looking to monetize patents. And there, it doesn't matter if you're an IBM, a Microsoft, or a Papst licensing. It is simply a much higher risk, and a lot of people these days seem to shy away because of this respective higher risk.
Right, and also we might have to mention that even though there is the possibility to challenge patents without being sued in Germany, the chance that a patent is invalidated is only about a third, let's say 33%, or maybe sometimes 34 or 35% in some years in opposition proceedings, and another third chance the patent is amended, the claims have to be narrowed, and in 1/3 of the chance the patent is held up in full with full claims. So that's very different from 80% of all claims being cancelled in inter partes reviews.
Right, and in the IPR proceedings, it seems a big challenge to amend the claims, which also seems a little unfair. You're facing a tougher review standard, and then if you try to amend your claims by incorporating features either from the specification or sometimes even from dependent claims, the board may not allow the respective added features in there, and that seems not very fair.
Yes. Let's see how that works out. I think some people already have strategies how to influence that system. So you certainly also follow the developments around the Unified Patent Court in Europe as a patent enforcer. Do you think the UPC in general is a good or a bad thing, and why do you think that?
We are very much looking forward to the Unified Patent Court. Unfortunately, it's not here yet, but we believe there is at least a groundwork made for an efficient proceeding, for a streamlined proceeding that gives you certainty in an overseeable time frame, and by that we believe it will be a helpful tool for every patent owner, and it certainly will cover a huge market of consumers, and by that we believe it's going to be giving quite some boost to the European patent landscape, and also the world taking a closer look at Europe for looking after monetizing or fighting respective patent battles.
Right. And one question would be, patent owners can opt out of the system. And as I understand you wouldn't really opt out your patents. You would try to use the new court system, basically.
That's right. At this point, we don't see a reason to opt out. I understand the arguments that pharmaceutical companies bring about, the approach of not having all eggs in one basket and only one decision that might later challenge the validity of all the national parts. But in the as my mentor becoming a patent attorney said, not every patent is valid. And it seems strange that a patent could be valid in Germany but not valid in France, and vice versa, even though we're potentially talking about the same exact claim language, and there should be the same interpretation level. But again, I understand pharmaceutical companies trying to hide behind that, but overall, we certainly look forward to that centralized proceeding and its efficient possibilities to resolve patent disputes.
Mm-hmm. You know that a German attorney at law brought the whole ratification process to a screeching halt when filing a complaint with the German Constitutional Court not too long ago. And people currently don't really know for sure whether this issue can be resolved before the actual Brexit of the UK. What is your personal opinion? Will the UPC really become a reality?
I am very much convinced that the UPC will become a reality. The question for me is really, when will we see this? The Brexit certainly has an impact that is not really be foreseeable. Will the UK ratify before they will exit the EU or not? And how could they possibly do that? But also that challenge in front of the German Constitutional Court. It's remarkable that the Constitutional Court picked it up. I believe the issue at hand is somewhat more focused on could the German parliament have elected or voted for this respective law with 50% plus one vote majority, or should they have had a qualified majority of 2/3 in the parliament? I am if I remember correctly, there were challenges of that nature before, whenever respective powers were given to the EU, and I'm hopeful that the German Constitutional Court will not say, okay, this is unconstitutional. Sorry, go back to square one, and which might throw things back years, but that they'll address it in a way that that makes it possible for a fairly timely ratification of Germany with the UPC.
So what I hear you saying is that you think that even if Germany would not ratify before the Brexit, I said Brexit, before the Brexit, if the UK ratifies before the Brexit and then leaves the EU, and then after the Brexit, Germany ratifies the UPC agreement, that would still lead to a functioning UPC, right? In your opinion?
I mean, the question then is how will the whole actual Brexit be handled, and the aspects of handling intellectual property and the questions of will the UK then still be allowed to host the UPC Central Division for the pharmaceutical and chemical aspects of technology in London. I guess those are questions that have to be negotiated by the people dealing with the Brexit negotiations. But I guess it's at this point probably esoteric, because there are too many unknown parameters to really come up with what if and how it'll actually turn out. I'm just hopeful it'll work out.
We all hope that, at least me and you hope that the UPC will become a reality before the actual Brexit.
Right.
So how do you prepare for the UPC and for enforcing patents using the system?
I'm not sure how much there is for us to prepare for. We try to at least let the market know that we're already located in the European Union, in the heart of the European Union in Germany, and that we are an avenue also for companies and patent owners from outside of the European Union to provide services for them in monetizing European patents, and that we will be ready once the UPC is up and running. Apart from that, as we touched upon earlier, we will not opt out with any of the patents that we, the European patents and respective national parts that we currently have under monetization. And as such, I think we're just trying to be ready when it comes. Again, we don't know when that happens, but we hope it'll be in the not too distant future.
Right. This has been a very interesting interview for our listeners, but unfortunately we had too little time to really cover your whole business model and how you enforce patents. So if people have questions for you, where can they reach you best?
I think it's easiest either to give us a call or to find us on the web, papstlicensing.com, and or just Google my name, Daniel Papst, and you will not be guided to the beer, but to the patent monetization activity that we offer. And so I believe it's those are probably the easiest ways to reach out to us.
Thank you very much for being on this interview.
It's been a pleasure, and I appreciate having had the chance to chat with you about the issues we talked about.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.